Vandana? Yeah, okay.
And you
Sorry, continue.
So, as everyone knows that the primary objective of inheritance planning is to ensure that your assets are transferred in a smooth, efficient, tax efficient, and a cost-effective manner to the beneficiaries in your family or otherwise, while you minimize tax liabilities. Today, we have Ranjana Aggarwal, a former EC member and a very, very, very seasoned expert on the subject of inheritance planning. I'm going to stop talking and pass the baton to Snimer, who is a current EC member and who's going to be moderating this talk with Ranjana. Over to you, Snimer.
Thank you, Preeti, and welcome, Ranjana. I've had the privilege of hearing Ranjana on this subject before. She has been the national president of FICCI Flow, and she had organized a talk for Flow, which was something I was able to attend soon after the COVID times, I think. And I really commend her knowledge and expertise. And today she's going to be giving us an idea of, well, an idea of the laws that impact inheritance planning and what some tools for inheritance planning and recognizing a time frame and what are the pitfalls of not planning. Preeti has briefly mentioned the pitfalls being leaving it to the government to decide, but Ranjana will tell us more on this. And Ranjana will speak for about 30 to 40 minutes, and then we can have time for questions and answers. Okay, over to you, Ranjana. Thank you.
Thank you. Thank you, Snimer.
Sorry, may I request everyone to mute themselves, please, so that there's no disturbance?
Thank you. Thank you so much, Snimer. It's a pleasure to be here on this forum. It's my home place. I'm an alumni, and it was Snimer, because of Snimer that I became an ELSA and joined the community, and have ever since felt very excited to be part of a group that I cherished those 3 years that I spent in LSR. So thank you, Preeti, for giving me this opportunity, and Ashima for organizing this, getting the whole meeting and the talk organized. Thank you. I know, this topic continues to be important, especially after COVID. During COVID, of course, everybody was very disturbed and was uncertain about life, so to speak. But I think we all recognize that the wealth that we have created with so much pain should actually peacefully go to the intended beneficiaries. So, with so much litigation around inheritance, this has become so important. I think writing a will is more of an emotional exercise for me, and I think for everyone, than a legal one. I like to sit with my clients and sometimes counsel them while understanding their predicament. Sometimes they want to sort of talk through their thoughts, who to give what to, amongst their beneficiaries. Like Preeti said, there are many tools available with us while doing inheritance planning. Writing a will, of course, is mandatory to my mind, and it is perhaps the first step. So sometimes, depending on the situation, we use different tools. For instance, if we have to provide for a special needs child or for the educational needs of grandchildren, or there is a possibility that siblings are likely to enter into a dispute, or there is a time frame that we know that these funds or my assets will be better utilized by my beneficiaries at different points of time. We use different tools. For instance, family trusts are made, and often they are found to be more useful. Like I said, there is no substitute to writing a will, but there are other things like parents also give gifts during their lifetime, because don't forget that inheritance will only come to you at a particular time when your parents typically are no more. And it is possible that at that time you may not need that inheritance. You may be too old. You want to enjoy some part of the assets that will eventually come to you during your lifetime. I think to that extent, parents recognize this today, and often you use the tool of gifting. Whether or not it is tax efficient or not is not the issue here, but it's more of a convenience or a tool to avoid disputes. Big businesses, for instance, use charters, family charters, to discipline family members with respect to sharing of profits and actually incurring expenses. So many times disputes arise more not because sharing of profits don't take place in a particular manner, but because there are differences, because one sibling does more expenditure than the other sibling. So expenses need to be also identified and managed. And this can be done through charters. Many big houses have a charter where the trust is on a father figure who is seen to be just and equitable, and he lays down what will go to whom at what time, and how the expenses will be done. A lot of high net worth individuals today use the services of wealth managers, etc., to manage their family office. A family office is typically like a concierge who manages your wealth and distributes to your beneficiaries according to a written mandate that is given to him from the individuals who have huge. It, of course, results in a lot of expenses of managing that family office. But it is efficient, but it is not a legal tool to that extent. There's no legality around it, but there is convenience. Sometimes people think that only by writing nominations they have done their job. Actually, it's not like that. Nominations don't give ownership. They only give the access to assets at the time of the death of a person. And the ownership is determined by law or by way of will. Coming back to the laws that govern inheritance, there are two basic laws that govern inheritance. One is the Hindu Succession Act, and the other is the Indian Succession Act of 1925. They decide who will get and in what proportion, and how the estate will be administered. They lay down the natural rights of legal heirs. So the laws are basically based on religion. And for instance, and also they decide if it is an immovable property, whether what will determine the distribution. The location of the asset. The movable assets are managed or administered basis the residential status of the person. So these laws actually define your rights and obligations in case you have not made a will. The first step, of course, in inheritance planning is to start thinking that what if I die without writing a will? Do I have a list of assets? Do I have passwords that are accessible to my beneficiaries? Have I put nominees against every movable assets? Have I decided who will execute my wishes? Who are the people that will witness my declaration of the intention of distribution of my assets? Who will be the witnesses, in other words? These are the few things that need to be determined, or in fact, you have to think about them before you start inheritance planning. Over here, I'd just like to remind that, normally when you file an income tax return, your chartered accountant does not ask you to prepare a balance sheet. And with the Wealth Tax Act being abolished, I think most people ignore writing the balance sheet or listing the assets. That results in a lot of pain to their beneficiaries. They don't know what the parent actually owns. It's all over the place. So, if you can ask your chartered accountant, start preparing my balance sheet, not even though it may not be useful for filing of your returns, but at least it will list down the assets that you have. And then you can, track them as you go along. So that's a step that I would encourage all of you to take. Of course, if you don't write a will, do you think it's worth it? I don't think so, because when you go for registration, for instance, of your properties, or for mutating your properties that you inherit, and you don't have a will, or even a registered will for that matter, the chances are that you will have to go for certificate from the court that certifying what will come to you. So the charges, the fee quote, etc., can be as much as 4% of the market value of the assets. So to that extent, there is a cost attached to not writing a will or not registering a will, for that matter. So, in fact, I was talking to Snimer and she said, what exactly is a will? Will is a declaration of my intention with respect to distribution of my estate to my beneficiaries. My beneficiaries need not be my legal heirs. They can be anybody. They can be people other than my legal heirs also. I can also give my intention as to whether I want to give some wealth to charity, whether I want to give something to somebody who is not related to me. So that also you can list in your will. So to that extent, it's flexible, and it gives you an opportunity to go beyond the legality of your inheritance passing. So the natural laws of inheritance become applicable under the Hindu Succession Act. This is basically based on religion. If you're a Hindu or a Sikh or a Jain or a Buddhist, the Hindu Succession Act of 1956 will apply. If you're a Christian, the Indian Succession Act will apply. Or if you are having an inter-religion marriage, then the Indian Succession Act of 1925 will apply. So for Muslims, of course, the Quran is defines how your assets will be divided in case there is no will. So you should be clear that in case you don't write a will, the law defines how your wealth will be inherited. For instance, if a female dies, her wealth will go first to her husband and her children. And if she does not have children and her husband is not there also, then it will go to the heirs of the husband. Now, who are the heirs of the husband? We'll come to that later, and you will know what can also happen. If none of the above are alive, for instance, if husband is not there, children are not there, then it will be equally, it will go to the mother and father of the female who dies. And if mother and father are not there, then the heirs of the father will inherit her property. Coming to the case of a male dying without writing a will, in that case, his wealth will go equally to his widow and his children and his mother, and also to the children of any predeceased child, if there is. So in that case, now supposing you don't have children and your husband is also not there, and you die as a female without writing a will, typically the next person who will inherit your property, if your mother-in-law is alive, all your property will go to her, because the heirs of the husband will inherit the female's property in case there is no one else. So you just need to be careful about these little things, and therefore get encouraged that it's very important to write a will. For instance, these days, I notice that there are a lot of divorces. And to that extent, I think it's imperative to touch upon that aspect also, especially to this group. What happens to the natural rights of people in case of a divorce? The ex-wife, of course, has no right on the property of her in-laws or her husband. Except, of course, the Shridhan that she can take with her. Her children have full rights over the property of their biological father, even after divorce, and even after their mother remarrying or the father remarrying. In case the mother remarries, the children of the mother have no right over the new father's assets unless he adopts those children. So that you should always remember. Legally adopted children have equal rights as the biological children. Now, I also thought it's important to touch upon live-in relationships. A lot of children today are interested or think it's okay to be in live-in relationships, and it's a global phenomena where marriages may or may not happen. So do they have rights when there is this type of a situation? To my mind, a live-in partner has equal rights as a legal wife. Even a child born out of this relationship will have equal rights over the property of the father. A live-in partner also has maintenance rights on the property of the deceased, even if she is disinherited under the will. So supposing a partner disinherits her live-in wife or a partner, a female, she still has the right to ask for maintenance from the court. Illegitimate children, what are the rights? Illegitimate children also have equal rights along with legitimate children. So I thought this was an important point that I introduced, I think, especially because seeing the current situation where people are actually faced with such situations. Now let's talk about the benefits of writing a will. Like I said, you can decide the share that each beneficiary will get. It need not be equal. In law, if there is no will, then it gets equally divided. But if you write a will, you can give unequal shares also. You can also decide when the property will be distributed. You can also decide whether the property at the time of death will be transferred to a trust. You can also disown a beneficiary. In fact, it is seen that more than 30% people in their wills want to disown some legal beneficiary or the other because of not getting along with that child or with the husband or whatever. And another benefit of writing a will is that it's not sacrosanct. You can always change the will anytime. Even after registering the will, you can write a will, and that latest will, even though it may not be registered, will be the last will that will be considered by courts. That will be the legal will. A lot of people want to understand, can we have joint wills, or what is the meaning of a concurrent will? Now, the question of concurrent wills normally comes up when you have assets in different countries, different jurisdictions. In that case, the question is, should you write one global will, or should you have different wills in different jurisdictions? There is no easy answer, because how the will is executed, what are the laws of different jurisdictions? If the laws are the same with respect to executing a will, writing a will, then also, to my mind, it's always better to have different wills in different jurisdictions. So that is somewhat a overarching statement I'm making, but of course, different situations will have different opinions. Most people will ask me, can we not make a mutual will? A mutual will, of course, the meaning is that there is no one will. There are say, husband will make his will, wife will make her will, and they will mutually decide that whatever is mine will go to you and whatever is yours will go to. So that's a simplistic way of putting it. A lot of people call it mutual wills, but there are two different wills where and of course, if both are not alive, then how is it distributed is also written over there. So that technically people call it mutual wills. I'm purposely giving you the names that are normally used when people talk about inheritance planning. So people will, so if you want to make an addition to your already registered will and you think that you've missed out something and a new thing has come up and you want to change your will, etc., you can make a additional document that can be attached to your original will and can be registered as a codicil. It's called a codicil in legal language. Now, who can make a will? Obviously, a person who is not of sound mind and who's not a major cannot make a will. So it's very important that while you are healthy and you are perceived to be healthy also by others, you should make a will. Otherwise, there are chances of dispute, because if the public at large sometimes perceives that, अब ये थोड़ा सा भूलने लगी हैं, या थोड़ा सा डिमेंशिया हो गया है, या उनको समझ में नहीं आता है, तो उस सिचुएशन में ना will can be potentially disputed later on. So better to make a will as quickly as possible, not really when you become very old, is what my suggestion would be. Now, so many times the question arises, what can you will? I come across people where people are not certain whether they own it or they just think that they own it. because sometimes you get all quite sure in family-owned assets that you have been using for quite some time that this is mine only. Although legally, because of some death in the family, some brother has died, he has children, but you're the one who's managing his children also, and you have sort of looked after the entire asset. In that situation, you think it's mine, but legally it may not be. Legally, you may be just owner of half the property, and you can only will what you own. So be very careful when you are writing a will to be sure that what you will is what you own. Otherwise, that will be considered, or that portion of the will where it says that this is what I give becomes null and void. So, for instance, some people ask, I have a partnership and I have a share in that partnership. Can I will that share? Yes, it is your asset. You can will it. However, make sure that that provision is there in the partnership deed also. If supposing the partnership deed is contrary to what you think that you own at the time of your death, then you can't will it, for instance. So whether you can will property in HUF, share in HUF, whether that is your property and can you will it? Yes, you can will it. That is a separate topic where we can talk about your rights under HUF, and especially after the Supreme Court rulings that allowed girls to be to have equal right in HUF property due to their birth. It is not so as soon as they are born, they have an equal right. This judgment came in 2005, and since then, under most circumstances, girls now can have equal rights in HUF properties. So that we can talk of in a separate session, because that's a longish kind of a conversation. How should you write and execute a will? So I think normally when we write a will, we introduce ourselves. We declare that we are writing this will voluntarily, and that we own the assets that we are bequeathing, and also list the legal beneficiaries. You can also write who will be the executor of your will. And in case you want to disown any of your legal beneficiaries, then you can write, I would suggest, for instance, give reasons and etc. in the document itself. Try not to be ambiguous. It's a skill. Remember, it's not just that I know what I'm gifting. It's a very simple document. Let me just write it. Sometimes you may land up into problem, not you, because you are already gone. The beneficiaries may have trouble later on in case you miss out a few clauses that sometimes help in inheriting wealth from your parents. So I would encourage that you get it vetted or written by an expert. In case, like I said, if you don't own it, become null and void. And it goes without saying that, try not to make too many cuttings in the document. You have to sign each page. You have to identify two witnesses. Even that is a task that should be considered with all seriousness, because a witness is the one, in case of dispute, becomes critical to tell the court whether you were of sane mind or not, or whether you were coerced into writing the will or not. And therefore, it's important that the witness understands or knows that you were of sane mind when you made that will. the questions that come up mostly are, should we register a will or not? Whether it is mandatory or not. No, it's not mandatory. You may or you may not register your will, but I will encourage that you register a will. It's not a very difficult task. You have to take an appointment online, and it's very easy. Otherwise, if you don't register, you might end up into problem, because then if there is a dispute and you have to, and the person who has to transfer the assets, and the asset is of very high value, he might ask you to get a succession certificate, or he might ask you to get a letter of administration, and you might have to go to the court. And the court fees is sometimes so high, it goes up to 4% in Delhi, especially, and at the market value of the asset. So you'll end up paying a lot of fees just to get possession of your inheritance. So I would encourage that you register your will. Some other tips that I can give while writing the will is that in order that there are no disputes, try and understand the wishes of your children beforehand. Sometimes people ask, should we share our will with the children or not? That's a personal choice. And it depends on circumstances of each case, and there is no hard and fast rule. But just remember that when you write a will, it should not be vague. It should be well drafted. Now, what happens after you die and the executor takes over control over your assets? With respect to filing of taxes, it takes, say, 3 to 4 years to execute the will, to transfer the assets. What happens? Income keeps accruing. Who will file the return, for instance? So those issues need to be also understood. The executor is responsible to file the returns, etc. So the job of an executor is a very important job, and he should be somebody who is willing to devote time on the execution of the will. And I think the best person is the beneficiary himself, unless there is a feeling that the beneficiary is not intelligent enough or chust nahi hai, matlab he is likely to dilly-dally at the cost of other beneficiaries, then it's best to appoint a professional. Even a CA firm, etc., through a partner, can be asked to execute a will. And that's a very good way, because then the transition happens more smoothly. So, like I said, it's the first step of writing a will. There are many other different ways of doing it. Because some people say that I've written a will, I think I'm sorted. The point is, sometimes it can be contested. You should remember that disputes may still arise, and especially because if you don't give equally to your children or to your beneficiaries, and you disown somebody, or you know that that person will not like what you have given to that person, so then chances are there could be a dispute, and therefore will can be contested. So in those circumstances, people normally go for a option like a family trust. They make a family trust. They transfer their movable, immovable properties to that trust at the cost of losing control sometimes, and also it's whether it's tax efficient or not has also to be seen. All this depends on the circumstances of every case. Gifting also involves some kind of stamp duty implications are there, even though there is no gift tax. But all this tax planning has to be done well in advance, I would say. At least understood that what are my options? If I take this route, what is the tax efficiency? If I take the other, what is the tax efficiency? How can I manage my assets in such a way that the pain to my beneficiaries is minimized? Because sometimes I find that beneficiaries have to give up even their jobs, and they spend many years after the demise just sorting out the wealth of their parents. So to that extent, I think I have covered ground in terms of right, the issues around wills. And I will ask Snimer to now take this forward.
Thank you, Ranjana. That was very interesting and very useful to understand the whys and hows of inheritance planning. And I'd like to kick off with just one or two questions. You mentioned that live-in relationships, the same rules would apply. What about same-sex partnerships?
I think same-sex partnerships are not legalized.
Okay, but live-in relationships are?
I think there are some court cases that the courts have given relief to one partner.
Okay, so there is some
Precedence.
basis for that. The other thing I wanted to ask about, and then I'll throw it open to the audience for questions, is we here talk about a living will. Living will is to express the wishes of the person in case he or she is not able to, in a health state, not able to make a decision. For instance, the do not resuscitate thing of if someone is very ill and not able to take a decision. Is this something which is legally covered, or is it still case law, or what?
So I think living will concept actually is related to medical to advise the family as to what should be done in case of a medical emergency.
Yes.
So it's basically an declaration given to family members where it is an open document. In fact, it should be shared with all the members as against a will, which is meant for inheritance. You need not share, but a living will, you must share. Because, and whether or not it's a legal document, whether courts will uphold it or not, is depends on circumstances of each case. I don't think the courts have declared that euthanasia is legal, for instance. I think what they have said is that under circumstances which are sometimes different in different cases, they give their verdict depending on every case. And if you write in a living will that if I'm on a ventilator for 20 days or 100 days or etc., then please take out and please let me go.
Right.
Even then, if there is a possibility of malfeasance or somebody acting against, or there's a possibility of revival and they just want to let the person go because of property reasons, then the courts will examine in each case.
Right. So it's not considered a legal document, a living
No,
will.
it's not considered a legal document. To the extent that I understand, I think Preeti might like to interject here and.
So
So,
I think we'll throw it open to questions. Either you could raise your hand or use the reaction. Yeah, Preeti.
sorry.
Please.
Uh, So what I wanted to really ask Ranjana over here, because I've seen this coming, it comes in fairly often. Like, you spoke about the fact that does not give you, nomination does not give you an ownership right. So
Yes.
nomination, qua succession are two different things altogether. What I have also realized and discovered over the years is that this is something people don't pay a lot of attention to,
Yeah.
because the moment somebody is a nominee, either in a bank account or in a mutual fund or in any investment, they think that they have an automatic right. So maybe I just thought if you can talk a little bit more about that, it'll be helpful. Just a
Yeah.
little bit.
Yeah, I think it's a very important topic. And I feel, like you rightly said, that people think that sheer nominations will give you the right to own a property. However, because it's a normal reaction, it's better that you align the two things. Whoever you want to give an asset to, make that person a nominee. Like, for instance, if you want to give, you have two children, you want to give the asset equally between the two. And nominations are normally used in movable assets. For instance, in a mutual fund, in a fixed deposit, or in a bank account, etc. Under such circumstances, align the two things. Because what happens is that if you give, say, one child as the nominee, that child will have full control over the asset. The will says that asset has to be divided equally between two children. Now, there's full likelihood of dispute, because the control over 100% of the asset is with one child. And the other child will then have to ask that person, please give me my 50% share. That person might not have any malfeasance or any malintention of not giving, but that child may delay their transfer. That itself will cause dispute. So nominations should also be aligned to your intention of inheritance, who you want to give. So, whereas nominations are useful to access the asset. If they are not there, you will not have access. For instance, in a mutual fund or in a share also. Without nominations, you will have to go for a succession certificate. And that succession certificate will carry a cost to it of almost 4%, 2 to 4% of the market value of the asset. If supposing a share was bought at 10%, and today the market value is 4,000 rupees, and that results in about 10 crores of worth of assets. Can you imagine paying 4% of that to the government just to get a succession certificate because you did not have a nominee? Today, of course, because of RBI rules and regulations, nominations have become mandatory. No bank is allowed to carry an asset without a nomination. So they are doing KYC, they are doing re-KYC, and nominations have become a must. So to that extent, I think that answers your question, Preeti.
Thank you. It really does, and I will stop asking more questions.
Why? That's a good question you asked.
No, let the others ask.
Yes, we have quite a few hands up. So I think Shreya was next in line.
So,
Shreya, your question?
thanks, Nimar. So this is not a question as much as an acknowledgement. My Ranjana is actually my mother. So I wanted to just say that she's really been a testament to doing estate planning for her father before he passed away, for the entire family. So I'm 37 years old. We all have wills that are registered, and we've openly had conversations around estate planning, because of which the intention of the parents, as well as, the needs of the children, have been discussed quite beautifully, and decisions taken, for instance, gift giving while parents are still alive. So just wanted to acknowledge the beauty of estate planning, and really encourage everyone to do it. And of course, thank my mother, who is here, to be, really the shining example. So thank you.
Thank you.
Thank you.
So, Asha, you had a question?
Yes, I did. Thank you so much, Ranjana, for that excellent presentation and for your superb inputs. Couple of points. I've done nominations that are aligned with intentions on movable assets, so that's not a problem. However, I've also written a will, and I got it signed by two witnesses. The witnesses only sign on the last page, if I'm not wrong. I've signed on all pages, so that should be okay. But I haven't had it registered. Why is it important to get it registered when I have a will and I have a couple of copies of the will? So it's not just one copy, and people know where to access it. So do I still need to get it registered? And also, how do I ensure that banks actually reach out to the people who've been nominated for different assets?
No. So your first question, whether registration is mandatory, like I said, it's not mandatory, but definitely I encourage everyone, because it sort of reduces dispute. One copy will lie with the registrar, so there's no tinkering with the will also. You can, of course, write subsequent wills and then get it registered, or even an unregistered will be valid. However, at the time of transfer of very valuable assets, where the registrar or the person who's mutating the property is uncomfortable to transfer because of the value of the property, बिकॉज उसके ऊपर कोई आंच नहीं आई, तो वो बोलता है कि रजिस्टर्ड विल होती तो आई विल नॉट आस्क for too many questions, or no objection certificate from everybody. So if some beneficiary is sitting outside the country, is not able to come, etc., and is not physically there, he will not transfer. The registration actually reduces the chances of any the time taken to transfer assets.
Shall we move on to the next? Isha, you had a question?
Hi Ranjana, hi Snimer. Thank you for the wonderful session. So the question I have is, I think it's more specific to my situation. So first question is, can the will have more than two witnesses?
Yeah, it can have more than two.
Okay, so like
Sometimes
father, mother.
people can't even get two. If there are more than two, then that's
But the
fine.
children can be the witnesses, right? So
No.
okay, so if we are the beneficiary, we cannot be the witness.
No.
Okay,
You
fine.
can be the executor of the will, but
All
witnesses
right.
have to be people other than beneficiaries.
Okay. And there's just a situation that we have in the family. My father-in-law is not, keeping very well. So there are 50-50, or I would say 70-30 assets distributed between my father-in-law and my mother-in-law. So we doubt like that he would live long, and to an extent, his sanity is also a little doubtful. So in that case, how do we? I mean, do we have if we enforce? Can we have wills made by both of them? Because there are certain assets which are owned by my mother-in-law, but we are more interested in those assets. So we presume that today my father-in-law will bequeath some property to us, but later we don't have a guarantee that the property that we have a heart and soul into, which is owned by my mother-in-law, she would be giving it to us, passing on to us.
That
So
is,
how can we uh,
how
no
can we manage this? You know,
yes,
you have to encourage both of them to write their will, because if you are able to have communicate, communication is very important. That and to understand what is their intention, because sometimes they don't want to talk, but sometimes it's best that that you talk, because after they pass away ना, हम लोग सोचते रह जाते हैं कि बात ही कर लेते हैं. तो इट्स
right.
इम्पोर्टेंट कि बात करके समझ लेना चाहिए, इनकरेज कर लेना चाहिए कि आप किसी को भी दें, डजेंट मैटर, बट जिसको भी दें वो ट्रांसफर में आसानी हो जाएगी. और अगर आप नहीं लिखेंगे विल, तो कितने लोगों में डिवाइड होगा, और डिवाइड हो भी नहीं पाएगा, तो फिर
Right.
कैसे करेंगे हम? उनसे समझ लें. You know, we can talk about this separately also, but the key, in fact, is to talk and to communicate.
Right, so it's better we get both the wills made at the same time.
Separately.
Separate, yeah.
Not necessarily at the same time, but definitely get both made. And if
But
possible,
can there be a clause? Because see, I see, being very frank, I see my mother-in-law living for another 10, 15 years maybe.
no, we
So,
can talk this separately also.
okay, yeah,
But by and large, I would encourage you to think of communicating and uh, making them understand that the importance of writing a will.
all right. Sounds good, yeah. Okay, thank you.
Richa had her hand up, but maybe her question has been answered. Richa, are you here?
Yeah, yes.
That's right, ma'am. Actually, I had the same question regarding whether the bennies could be a witness or not, because we were thinking that if all the bennies could be a witness to the will, then the chances of a dispute arising at a later stage or contesting a will would be reduced that much more. So I thought, but ma'am just answered the question saying that possibly the bennies can't be witness.
Right. Thank you. I see two questions in the chat. Rohini wanted to know if the age of the witness has to be younger than that of the one who is making a will.
No. So typically, one suggests that a witness must outlive the person who's making the will, because in case of a dispute, then he will be required to go to the court. But you never know what happens in life. So there's no hard and fast rule. It can be somebody of a older age also. It doesn't matter.
So, okay. Saroj has her hand up as well as the question in the chat. So, Saroj, would you like to ask?
Yes, Ranjana, I have one question. That in a situation where there are three properties of different sizes, and there are three nominees there are three beneficiaries you have to be given.
I'm not able to understand. I think there's an echo.
Or shall I just read out the question?
Yeah, do that. Yes, do that.
Saroj wants to know if there are three properties of different sizes stroke value. How do we will to three children in equal as far as possible shares?
Yeah. This is a normal question that every parent and everybody has to deal with, And one thing that I would like to counsel, rather, it's not a legal thing. It's just that I feel that, parents must try and give one child one property and not mix the two things. Mix ownership of one immobile property to three people. What happens is, supposing a child is living in a property and you give a equal share to another person. That person who's living in the property will not vacate it. He doesn't have the liquid cash to pay half the market value of that property to the other inheritor. So the other inheritor actually gets zero. Parents believe that they have done the right thing. But in fact, they have not realized that one child will not get anything, that it will get into a dispute. If that child goes to court, then nobody will get anything, and for years on end, and the property will not get sold, nothing will happen to it. So if there are 3 properties of unequal value, give it to 3 different people and compensate by some movable asset to the extent it's possible, or sell all 3, or write some things in the will which will equalize, or in other words, try and equalize in some other way, or other arithmetic that you can have, but that is circumstantial, and every time you write a will, these issues arise, and every time you have to deal with it separately. Pros and cons.
Thank you.
There's no hard and fast answer to this.
Thank you. We can hear you. Thank you.
We have one more question in the chat from Himali. If a property has been mutated to the inheritor on the basis of a notarized, attested will, can selling the property later be problematic because of an unregistered notarized will, despite it being mutated? That is more of a legal question.
So there is a difference between registration of a property, mutation of a property, and registration of a will. So she is asking all 3 things. So mutation happens with revenue authorities. That means with property tax authorities, with the electric company and the water. That's where the mutation.
I'd like to interrupt here. Hi, Ranjana. This is Himali here. Actually, the property is mutated because it's a leasehold. It's not yet mutated. I'm going through the process. But when it's a leasehold property, you have to mutate it and then you have to later convert it to freehold. Let's say I get it converted to freehold and then I decide to sell it. My father's will is only notarized, not registered. Suppose I decide to sell it later. Can a potential buyer give me problems because the will is not registered?
That's what I was asking actually. कि म्यूटेशन अलग चीज होती है. म्यूटेशन सिर्फ रेवेन्यू रिकॉर्ड्स में नाम on the basis of the will accept कर लेता है. रेवेन्यू रिकॉर्ड्स will accept it. But उस प्रॉपर्टी को रजिस्टर भी करना होता है with the registrar. एंड वहां पर जाकर ये नोटराइज्ड विल काम कर लेगी. बट एनओसी मांगेंगे with all the legal heirs. अगर सब लोग एनओसी दे देते हैं, सब लोग चले जाते हैं, रजिस्टर हो जाता है, तो वो रजिस्टर पहले करा लेना चाहिए उस प्रॉपर्टी को इन रिस्पेक्टिव बेनिफिशरीज नेम. जब वो रजिस्टर हो जाती है एसेट, तब आप उसको बेच सकते हैं बाद में.
अच्छा, तब विल क्वेश्चन नहीं होगा ना?
नेचुरली, बिकॉज आपने रजिस्टर कर लिया है.
सही बात. ठीक. ओके, थैंक यू.
Shweta has a question. Can a Hindu couple who doesn't want children decide to get married under the Special Marriages Act in order to avoid the patriarchal nature of the Hindu Succession Act, where husband's side will get wife's assets? What succession law will apply to them if woman's side parents are no more?
Yeah, so if 2 Hindus marry under the Special Marriage Act, even then the Hindu Succession Act will apply.
Okay. Then
there's a question from Rekha also here.
Yeah, I'm just coming to that.
Yeah.
If parents have only one child and don't write a will, won't the assets go automatically to the child? would the siblings of either parent or their children have any claim on the assets?
How will that one child prove that he doesn't have more siblings? So it's better to write a will.
Rekha, any further question on that? Okay. Okay. And I think that's all the questions, and we also run out of time. So thank you, Ranjana. It's been a wonderful session, and with your wealth of experience and knowledge, it's given us a good idea of the various aspects of inheritance planning. And thank you very much for that. I'm sure many of us will want to get back to you on this for further help. Over to you, Ashima, to close the session.
Yeah, thank you, Snimer. That was a great session, Ranjana. I think I did say that, I had a lot of queries regarding the topic that we were talking about today. And I think most of them, I think a lot of them have already been answered. And I think for some of them which still remain unanswered, I'm sure some of us are going to kind of, hound you for that and get back to you on it. But it was such an amazing session full of, knowledge that we do keep thinking about, and we at times feel that we're going to answer those questions. So for you to come here on this platform and give us this wealth of knowledge was a huge takeaway for all of us. And we are going to be putting this recording on our website, and I'm sure there are going to be many more people who will get back to you on this.
I just hope some of the reactions that I had are backed by legal precedents.
So we have Preeti to back out.
No, I think, sorry to chime in like this, but I do think what you stated was practical. Okay. And at the end of the day, the law doesn't go only on what the law says, but also what is in practice. And your insights, experiential insights, have been just wonderful. So even if it is backed or not backed, India is a common law country. I don't know.
Right.
I would just say the beauty or the subjectivity of this is a nightmare for some of us. But I think everything that you said made perfect sense to me. And so really thank you for, bringing what you brought to this table and for to all of us.
Absolutely.
Like I said, the last words, I would just like to say that for me, why this topic is so I'm passionate about is because I find that a lot of people have to suffer family disputes and, fighting with siblings and all of that. And I do feel sometimes they take it very lightly. थोड़ी tax planning कर लेनी चाहिए. Will, there's an expertise to writing a will. कैसे लिखो, कोई भूल ना जाओ, कोई सेंटेंस ना भूल जाओ. Because I know practically कि एक जगह एक सेंटेंस हम भूल गए थे, उसकी वजह से हमारे we had to pay 4% taxes just to get a succession certificate. And it was because it was not properly vetted. They did a good job of the will, but the एक sentence भूल गए. So what I'm saying is कि these are and dispute हो जाते हैं. Like that question on whether if there's only one child, why should we write a will? That's a very common question. But how will, if there is a dispute, how will anybody know that there's one child or two children or three children? Only a legal document where you have listed down your legal beneficiaries. And then you have gone on to say कि ये मेरे legal beneficiaries हैं, लेकिन मैं इन सबको देना चाहती हूँ और उनको नहीं देना चाहती हूँ, for instance. तो मतलब it's a document where intentions are very well documented and should be documented in a very sometimes elaborate manner, not just vague, ambiguous manner. And then the will becomes totally disputable. Anyway.
Thank you so much, Ranjana.
Snimer, I want to just ask Ranjana, request her. Next time, Ranjana, could we also have a discussion on the gift laws? Because they're very interrelated, the will and the gift laws also.
And also, we can talk about trust. We can talk about gift, definitely. And
sure.
Also, I did not, I forgot completely actually, the laws relating to transfer of assets to NRI children.
So Ranjana, if we can list out these topics, maybe we can schedule one more talk on gift laws and transfer of assets to NRI, to children living as NRIs.
Yeah, because
yes.
हम सबके बच्चे बाहर रहते हैं. So everybody is thinking हम उनको कैसे दें, कैसे पहुंचाएं.
So again, I think maybe this in itself can become one complete session. So let's note it down, and we'll schedule one more talk with Ranjana. Basis these topics, Kavita, point noted, and shortly we will come back on this, Ranjana, right? So thank you so much. Today we are already out of time. So thank you so much for being here, and thank you, Simar, for moderating it. In spite of your not being well, it was great to have all the participants, all ELSAs participating, and I'm sure all of us stand to gain out of it. For sure. Thank you, Ranjana, one more time. Right? Vandana, you can stop recording now, please.